It's Conduit News Radio with Paul Harrell.
Hey, folks, please welcome back to the program. We have the state representative from District 97, Mr. Bob Ballinger, is with us. Bob, thanks for coming on, sir.
Thank you for having me, Paul.
And I also know that it's early, and trust me, I understand because I have to do this every single day.
So. Yeah, I was thinking that the background tweets in your, in the opening audio,
yes,
from birds. I think you have to do that because birds don't get up before the sun.
Yeah,
so,
that's exactly right.
It make people feel like it's it's actually morning and not middle of the night.
Yeah, I appreciate that. That's why that's why we put them in there. All right. So listen, the reason I want to have you on, I did a segment, a couple of days ago, and it has to do with your bill, HB 1006. And the companion bill was SB 5 over in the Senate, Senator Jeremy Hutchinson's bill, and it has gotten criticism. And I'm honestly a little confused about it because I heard your comments about it was the right, it was to restore the right to waive your right to a jury trial. There are other people that were saying no, this was about taking away the right to a jury trial. So can you just explain it to us, please?
Sure. And let me start with the understanding that it actually wasn't my bill. So Jeremy Hutchinson was working with the Bankers Association to try to fix this during the session, and they needed somebody on the House end to run it. They actually talked to somebody else first. I was busy at that time trying to do cleanup language for the enhanced carry stuff, so I didn't want to do it, but they didn't really have somebody else they felt like was positioned to be able to carry it. So they came to me with that bill. And so all it does, and I think that the history of it is, historically, we have a right to contract. Like me and you can contract to do anything we want, so long as, one, we're not breaking the law, or, we're not violating the Constitution, right? So that's what we've had forever in Arkansas. Well, we had a Supreme Court decision that came down in the last few months that essentially said, no, there's no provision set up in Arkansas law to provide for the waiver of the jury trial. There is a provision set up in Arkansas law for doing binding arbitration, but there's nothing that shows that in the same way the legislature didn't act, it didn't set up the waiver of jury trial. So, you have an absolute right to trial by jury. That's in our Constitution. However, that right can be waived in accordance, this is what the Constitution says, in accordance with provisions in the law. Well, the Supreme Court said, well, that never happened, so you need to do it. And I actually don't have a problem. I think a reasonable interpretation of the Constitution comes to that point. So essentially they said, if you're going to do it, instructed us to do it. So now we have, thousands of contracts out there that have that provision in there because, we always could. Two people have an absolute right to contract to whatever they want to do as long as it doesn't violate the law in one form or another. And so essentially where the reason why the bill was brought, first and foremost, the reason why it was an emergency is you have people out there who are right now looking at getting a house, buying a house, and they're looking at getting a secondary market loan because you get better interest rate when you get a secondary market loan. There are loans out there that were closed as a secondary market loan that hadn't yet been bought by the secondary market, the bigger banks who buy them. And so there is essentially a provision that's in the contract that the Supreme Court has declared unconstitutional. These are provisions that two grown-ups, two people who, have their capacities or else it wouldn't be a valid contract, who went in together and agreed to whatever it is, that now one provision, because the act of the state said that provision is no longer valid. And so all this did was restore that. And so they've caught on to some language within the bill that is essentially just contract language, where it says, it's presumptively valid, it's enforceable, it's irrevocable. And let me say this, I didn't like the language irrevocable myself. I didn't think that the language irrevocable, this was supposed to be ran in the Senate first, and there was going to be a bunch of things. When I saw the language irrevocable, I didn't like that, even though there's no such thing as something that's completely irrevocable, as long as the parties agree.
Can you walk us through what happened then? I mean, you mentioned that this bill was the Bankers Association bill. To me,
right.
It doesn't necessarily come across as, it's certainly a special interest, but that doesn't necessarily come across as something that is, for the people in general. But just kind of walk us through because it failed the first time because of the language, and it wasn't just with the bankers. Some people describe this as a backdoor tort reform for the nursing homes. So what happened? Why did it fail the first time, and then it was later amended? What was that language about?
Well, and let me first start with the answer. The bankers are people. Most of them in Arkansas are small-town bankers who are the ones who fund the local soccer teams and are the ones that help out every time that there's any kind of community thing where there's charity fundraising. These are just citizens, and on top of that, anybody who's went out and bought a house, you purchased a home. You probably tried to purchase a home with a secondary market loan because it's a cheaper interest rate. Every home buyer, every first-time home buyer, every person out there who's looking to buy a house, this provision's in there. Okay, so that's I mean, we're talking about people. So the Bankers Association brought it to us because they're the ones who saw it and realized that it's a problem.
So you're saying, I want to get back to that last question here in a minute, but so you're saying now when people sign a loan, the bankers can now put in there, you waive your right to trial by jury. Is that what's going on?
Yes, and they always have done that in the past. I mean, it's in there. It's in their uniform, just like 48 other states have it. On the secondary market, they have that language in there. And let me say this: they're not waiving their right to a jury. They can still go before a judge. And the alternative, like I said early on, binding arbitration is legal and lawful in Arkansas. So if you don't have the ability for this provision, then they will put binding arbitration. That means you don't go to court at all. That means you lose all the protections of court. You go to binding arbitration. Mm-hmm. So, and that has been upheld. So, this would at least you get the opportunity to go before a judge with all the protections associated with court. So, then coming to the next question of the
tort reform,
backdoor tort
reform.
Okay, and me, I'm in fact the Republican Party platform has tort reform in it. I support tort reform, and I think that the version of tort reform we're working is great. This is not that. All this does is deal with contracts and the enforceability of contracts. If somebody goes out and they engage in negligence or gross misconduct or whatever, you can get outside of the contract. You can go out there and you can sue them for those other things. I mean, it had nothing to do with that. To act like it had. And by the way, binding arbitration.
I guess my question, then why the fuss? I mean, if it had nothing to do with it, why did they have to amend the bill? I mean, obviously people thought, it was going to take advantage of maybe, elderly people that are going into nursing home. They don't necessarily know what they're signing. And then, of course, like you said, they had that language in that was irrevocable.
Right. I think you've got two major reasons. One is because of the fact that it wasn't a special session, we didn't have the time to counteract a lot of misinformation that was being put out, and so we had to get something done that would fix the most immediate, the most pressing problem that we had, and that was with so we yielded, it gave up on going as far as protecting all the rights for the citizens that I think we should have done, but we yielded to do that in order to get done. It was being pragmatic to get done what we could get done. And the other thing that I would say is the unholy alliance between trial lawyers and the family council, because I don't get it. I don't understand it. I'm a person who has stayed up late nights, worked really hard, been had hundreds of people at one time scream, "Shame on you," because I was working towards the same goal as the family council. And then as soon as we're in an issue where they are siding with the trial lawyers, who by the way give like 90% of their money to Democrats, they're the ones who fund candidates who want to take away our rights, take away our gun rights, and kill babies. That's what they fund, those people. And
I think, and actually we've got Jerry Cox, president of the Family Council. He's coming up at 7:33. I guess my question is you said that the bill you wish it would have passed, I guess, as its intent originally. And I'm trying to be clear. Did you say it was a moot point on the situation with nursing homes? And I mean, if they could still sue for negligence, then why put it in? I'm curious if they could still sue for negligence. Obviously,
because you do it.
Go ahead.
You do it for the contract itself. And then let me say this: that if what he is saying is true, is that there are that there are ways to do this to make it where you take the jury out altogether in some other egregious case, then you could do that already with binding arbitration. That is, the Supreme Court has said binding arbitration is legal, and that you can do that. And so it really is, to me, it's crazy, because the alternative here is to take away the court altogether. And I'm an attorney. I believe in the justice system. I believe in the jury system. But I also believe in the individual's right to decide. So it's not a right if we don't have the right to waive it. It's an obligation.
But don't you think every nursing home? Don't you think every nursing home in the state would have a contract? I mean, I don't think anybody would have any options to go into a nursing home without this provision being in the contract. I think most people would be forced to go live in the nursing home and be giving away their right to trial by jury.
I've never looked at nursing home contracts, but my guess is that it's already in there, because for hundreds of years, essentially, since the beginning of time, the people had the right to waive their trial by jury. It was only recently that a Supreme Court decision said, no, you don't have the right, because it's never been set up in the Constitution. And so this only restored it back to where it was. It didn't go any further than where it was. It only restored it back to where it was. And then, and let me say this.
Well, we don't know that, because we don't necessarily know that. You just said you've never looked at a nursing home contract. I mean, that's an assumption. I mean, I haven't either.
No. I'm talking about the law. I know what that is, but I'm talking about the law. I don't know what. I mean, the point is that it whatever was legal prior to that Supreme Court decision and valid and enforceable would be legal, valid, and enforceable now. So I don't know what it's what the nursing home contracts have is irrelevant, because what this does is this just restores back to where the law is. I mean, and that's easy to see. You can read the bill. You can say, what was the law a few months ago regarding contracts? What is the law now regarding contracts? And you can do it. I mean, it's easy to look and say, if people want to talk about, the fact that you didn't read the contracts, not an excuse or defense. Well, that's what the law is. It was probably redundant and unnecessary, and that's one reason why we took like all of Section B out, I think. And it shouldn't have ever been in the bill in the first place. But all it did was just restate what the law is. That just because you didn't understand a provision, just because you didn't read a provision, you're still bound by the contract that you've signed. Now, if you don't understand it because you don't have your capacities, you don't have the ability to enter into a contract. That's also the law, and this wouldn't change any of that.
So I have to ask this, because we're always talking about special interest, and so I'm curious, and I know you said this was not your bill. I mean, I know it technically, it's you're the sponsor of it, but I know you say it's more Jeremy Hutchinson's bill and it's the Bankers Association, and to me it just seems like
I carried it.
Right, so
I believe in it.
There's nursing home stuff here, but I just have to ask. I mean, you said you are an attorney. I know you're an attorney, so I mean, does your law firm? I mean, do they have any clients that are, nursing homes or Bankers Association or anything like that?
Nope, never. So we don't do any work. Well, and let me say this: that it's possible that Travis could do some work for a bank. I don't think so. I mean, if we do, we don't do much work, because I'd know about it if we did.
Okay, so
I don't think we do any work for a bank. No work for big insurance companies. With no work for nursing home companies. This causes a little bit of tension. Anytime that I engage in anything toward reform between me. I mean, we are more of a plaintiff's firm than we are a defense firm.
Okay, so you do think that this was a tort reform measure?
No, not at all.
Okay,
not at all. I don't think so. I never once talked to anybody in nursing home about this. And good example, Jeremy Hutchinson had the bill. It was his bill. When's the last time you seen Jeremy Hutchinson jumping up and down for tort reform? That's not his thing. He votes against every form of tort reform. He's a trial lawyer. That's his position. So we were working on this bill just to restore this contract right. People have misconstrued this in order to further their agenda. And honestly, it breaks my heart, because I was friends with Jerry. In the kind of level of friendship that you only get when you go through the trenches and you're in war together. I feel like I can't imagine why that Jerry would want to go down this path to cut the knees out from all these people. I mean, it's really easy to see The people who voted for tort reform, look at their pro-life voting record. The people who voted against tort reform, look at their anti-life record.
Well, so let me ask you this, because he's going to be on here in a minute, but I do know one of his points would be that he's a pro-life organization, and he sees some of these efforts as actually diminishing the value of life in the judicial system. What would your response to that be?
That's jargon, because the value of life is set in one place. The value of life is set by your compensatory damages, by the damages associated with what the value of life is. And it's stick to the idea of putting a dollar amount, but that happens every time you have a wrongful death suit. You go out and you say, what are the compensatory damages? And no form of tort reform, Issue 1 doesn't touch that at all. Issue 1 touches, and this is debatable, right? Should we put some sort of cap on pain and suffering? That is the area that there is a $500,000 cap on. Even the punitive damages is capped at 3 times whatever compensatory is. So you could be talking about in the millions the punitive damages. So the only place that's capped by this provision is the non-economic damages, things like pain and suffering. And it is debatable about whether you should have a $500,000 cap on it. It came to the House with a $250,000 cap. My amendment changed it to a $500,000 cap. Jerry Cox supported a provision with $1 million cap on it, and lobbied for that provision. So, I think really the question is not whether or not there should be a cap. The question is what the cap should be. That's a policy decision. Which branch of government makes policy decisions? You're constitutional. Who should make the policy decision?
We are out of time. State Representative Bob Ballinger, I appreciate you coming on.
Yeah,
and I'll tell you this. I'll tell you this though. I'm against the so-called tort reform that's coming up in this November, and it's because I stand up for your right as an attorney to not be told that you can't make over a certain amount. So, but we can save that for another time.
Yeah, I get that, Paul, but that's also something we can change in the legislature and debate it, and that's a good policy argument that we need to make.
I appreciate you being on, State Representative Bob Ballinger. Folks, don't go anywhere. We'll be back in just a moment. All right, ladies and gentlemen, welcome back. Thanks so much for being with us. Joining us now, we have the president of the Family Council. You can find out more. It's familycouncil.org. Mr. Jerry Cox is back with us. Jerry, thanks for coming back on, sir.
Well, it's always a pleasure to be on your show.
I appreciate that. Well, it's a pleasure for it's always a pleasure for us when we have you on. So I followed this story, I guess, a couple of days ago. I read your post over at the Family Council. Did you know lawmakers nearly voted to let you unknowingly waive your right to a jury trial? This was Representative Bob Ballinger's bill. He just was on the program, as well as Jeremy Hutchinson was running it in the Senate. And, let me just start with Bob Ballinger, when he was just on the program, said that the Family Council and the trial lawyers have an unholy alliance. Let me just get your reaction to that before we get into this.
Let me tell you, we were fighting this stuff before Bob Ballinger ever thought about coming to the state capitol building. Our record on this goes back to 2003. I've been going to the Capitol almost 30 years and lobbying for biblical values and so forth, and I've seen everything imaginable come down the pike. I started when Bill Clinton was governor, and this is just more mess being fostered on the people of Arkansas, and I'm not going to stand for it. And so if the trial lawyers happen to be on the same road that I'm on, then that's just the way it is. But we are our own organization. We always have been, and we always will be. Let me say this about that bill. That thing was so bad that first of all, they filed the bill with 1 hour's notice. Most people on that committee had not even read the bill. They filed it 1 hour before it was to be heard in committee. And so at most, they might have had an hour and a half or a little bit more, but virtually no time to read it. And they said so much in the committee. And I might say that the people on that committee, Democrats and Republicans, both rejected it. And here's why. They said it was way too broad. It was billed as a banking bill, but when they opened it up and read it, it said all contracts. Well, think about it. Representative Doug House said, so you mean when I go on the internet and I buy something or I rent something or I agree to the terms, he said, you mean they could bury down in that my waiving my right to a jury trial? And the answer was yes.
Wow.
So, Paul, how many times do you click agree when you go online to download an app or, whatever? And that's how broad that bill was, because it would have applied to all contracts. And so if you got wronged, then you'd have to go to some binding arbitration in front of some politically motivated committee, I'm afraid, instead of getting to go in front of a jury of your friends and neighbors. And so it's a basic Seventh Amendment right to be able to have a jury trial. I mean, that's in the Constitution of the United States and in the Arkansas Constitution. And so one of the committee members asked me, said, Mr. Cox, why are you even here testifying on this bill? And I said, how many old people do you think know that you guys are running this bill this morning? I said, we're lobbyists. We had 1 hour's notice, and we just barely could get here. How many old people out there know that you're doing this? And I said, an old person can go down here and check themselves into a nursing home. And when that nursing home puts a big stack of papers in front of them and they say sign, that old person's going to sign every one of those pages. And they're going to unknowingly, I'm afraid, waive their right to a jury trial if somebody abuses them or neglects them in that nursing home.
Mm-hmm.
And not only that, but they will have also waived the right of third parties to have a jury trial. So that means none of their kids could sue either if that nursing home killed that old person, caused their death. And so it was just so egregious. And also, it had a provision in there that said failure to read, failure to know, or failure to understand the terms is not an excuse. It's still enforceable. And so if somebody failed to explain it to that old person, then too bad, dude. You still waived your right, and it's still binding. And, Paul, this is the third leg of what the nursing home lobby was trying to do to people as far back as 2003. I know it because I was there, and we fought it then, and we're fighting it now. And so the easy thing for people to say is, oh, well, he's just in with this group of people. Well, that's absolutely not true, and our record proves that we are our own person. If somebody comes along and starts working on this, they're joining us. We're not joining them, because I've been there, like I said, since 2003 on these kinds of issues. And when I saw this third leg of the nursing home effort, because the other two legs are in issue 1, which will be on the ballot this November, they put that in a ballot measure, and then they put this thing in this bill. Fortunately, it didn't pass. Fortunately, it was amended back to where it's pretty innocuous, but it was almost a really bad deal for the people of Arkansas.
Mm-hmm. We're talking with Jerry Cox. He's the president of the Family Council. So how are you? How are you guys doing? And the reason I ask that is because there are a lot of it seems like a lot of Republicans who support the concept of tort reform, and so they are automatically, and even many voted for the bill that's going to be on the ballot that I think is bad tort reform. I think it goes way too far, and I can get into all of that. But it's like you said, what are you doing here? Why does this concern you? And I think it's interesting that a lot of people are now wanting not just the Family Council but other organizations to be a Republican organization at all costs. You know what I'm saying? And they're upset that there's a difference of opinion on this issue. How are you doing on that?
Well, first of all, Family Council is a Christian organization, and we do our dead level best to go out there and uphold biblical values. And that's our first and foremost obligation. Always has been, and it always will be. And so when I look at what the Bible has to say about justice, what the Bible has to say about what it calls the least of these, the little person out there who is poor or disabled or can't speak for themselves. Paul, that's why we speak up for the unborn. They can't speak for themselves, and abortion takes their lives. And so when we say that we are pro-life, I don't just mean anti-abortion. I mean we're in favor of the dignity and sanctity of human life from the moment of conception until the moment of natural death. And if we create a system out here where entities like nursing homes or long-term care facilities can get away with offering way, way substandard care to people, then we're disrespecting the dignity of human life. I think how we treat old people is just as important as how we treat the unborn and the disabled and so forth. And so we've always been out there on that issue because of our respect for the sanctity of every innocent human life out there. And so if we would be disingenuous if we didn't speak on this issue. If we just said, oh, we're just concerned about unborn babies, but not anybody else. That's not really being pro-life. That's just being partly pro-life. And so that's why we're out there on it. That's why we've been there, and that's why we're going to continue to be there.
That's really good. I mean, I appreciate you guys, being consistent on that. So let me just be clear. When we just had State Representative Ballinger on, and when I told him, I said, was this bill in the special session, HB 1006 and SB 5, was it, backdoor tort reform? Is that what they were trying to do? And, he says, no, absolutely not. And so you're saying, no, this has always been one of the goals of the nursing home. And matter of fact, a lot of people think issue 1 is a tort reform written specifically for the nursing home. Just want to be clear. You think this is tort reform, or it was an attempt at tort reform?
Absolutely. Whether it was deliberate on Bob Ballinger's part or anyone else, I have no idea what was in their head. But I will promise you it was the third leg of the nursing home tort reform effort all the way back to 2003. And, Paul, I think it's important to point out what you alluded to earlier. We have always supported responsible tort reform. We supported SJR 13 a year ago. That would have been a more responsible measure that would have struck a better balance between favoring the industries like Walmart and Tyson's, nursing homes and hospitals and the Chamber of Commerce, and the little guy out here who buys a set of Firestone tires that come apart and kills his wife, or somebody who buys a vehicle with an exploding gas tank and it kills their teenage daughter, or somebody who, is wronged in some way. Those people still need their rights, and they still have a right to a jury trial. And what issue 1 and these other entities out there seem to be doing is tilting the balance way, way over here in favor of industries and business and nursing homes and hospitals, so that the little man is the one with the short end of the stick. And the thing is, Paul, those people will be abused and die in some of these facilities or at the hands of some of these business interests, I fear. And you'll never hear about it because these are little people that live out here somewhere in a little house down some little dirt road. And they don't have a lobbyist at the Capitol. They don't have a loud voice. And so somebody has to speak up for them. Again, just like we're trying to speak up for the unborn, just like we're trying to speak up for what the Bible would call the least of these. And it makes me angry when I see the powerful out here doing legislation that would put those little people at a disadvantage.
Yeah. And I just want to, first of all, I want to say thank you, because if you read this entire post over at familycouncil.org, it's clear that this bill would have passed had you not been on your game and gotten over there in less than an hour. And the reason, and this is another thing, it's frustrating to me, Jerry, because like you said, people thought this was just about banking. And Bob even said this was the Bankers Association bill, but then tucked in there, you have this hidden agenda, for the nursing homes is what it appears like. And if you hadn't have been, on your game, we may just be finding out about this, but the special session's over and the thing's law now.
I believe that's correct. A member of my staff looked at me when we walked out and said, I think that thing would have passed if we hadn't been here. And we'll never know for sure, but I just know as soon as it was defeated in committee, then the sponsors of the bill in the Senate began to work to amend the bill and make it a more palatable bill. But I don't think they were willing to amend until it was defeated on the House side. And I had members of the committee look me straight in the eye, and they said, this is more than I thought it was going to be. They just, talked to me like it was going to be a banking bill and, non-controversial. And so my belief is that it may have started out as a banking bill, and then these other entities saw an opportunity, and so they found a way to latch on to the bill and, maybe ride the bill through and get some things that the bill was never supposed to do.
Wow. Yeah, we're very close there. And so when they amended the bill, Jerry, they basically deleted what the controversial provision, correct?
Well, mostly. They said it only applies to lending institutions. And it would take another program for me to explain or you to explain why this even came up. But it had to do with some home loan legislation and some agreement to do binding arbitration instead of a jury trial and all that. And Supreme Court issued a ruling, and the legislature was supposed to be trying to fix that. And so they dialed it back to where it does apply to lending institutions. So if you sign a mortgage, you better read it, because you may be agreeing to waive your right to a jury trial if the bank or the lending institution does you wrong. Same thing would be true with getting a credit card or anything similar to a payday loan, like these payday lenders that are trying to get back into Arkansas. So buyer beware on signing any kind of loan agreement, because this new law gives them the ability to bury in the contract your ability to waive your right to a jury trial if somehow you're wrong. So, and so that's just something to be aware of. But we're not a banking lobby, and so we backed off of it. And as far as I know, the bill really didn't have any organized opposition.
Yeah. Okay. So last question, and I just want to tell our audience, we're talking with Jerry Cox. He's the president of the Family Council. He's been at the Marble Palace, doing this for 30 years, and he's been trying to stand up for the unborn, for Christian values, for traditional American family values. You were doing this when there were mostly Democrats down there, and I would venture to say that you couldn't really get much traction on some of the issues that we now have traction on. And I just think it's so interesting how quickly, just because we have a disagreement on one issue, and it's not a disagreement on tort reform, it's just a disagreement on this specific concept of tort reform specific for the nursing home, and you have establishment forces now, it's like what Bob Ballinger said, classifying it as an unholy alliance between family counsel and trial lawyers. I find it sad for a guy like you, Jerry, who has, you have been sacrificing your time and leading an effort for a very long time, and now, we're going to let one issue, kind of, I don't know, potentially ruin some relationships, and I hope that's not the case. Can you respond to that?
Well, there are much more reasonable members of the General Assembly who don't see the same way we do on issues like this kind of tort reform, as you said. But you know what? We're still friends. We still work together on the other things. I find it really, really sad that I could agree with some people 98% of the time, and if there's a 2% disagreement, then they're ready to throw everything out here on the trash heap and be our enemy. And that's not how we're supposed to operate. It's not how we operate. I kind of operate under the Reagan philosophy that, I forget what percent he said, but if we agree 80% of the time, then let's work on the 80% where we agree, and we'll agree to disagree on the other.
Yeah.
But this venomous attitude toward us as an organization and all that's not going to get us anywhere. And it's not the right way to be.
Yeah.
So we reach out and try to be cordial toward everybody. That's how we've been able to function in that building out there. The Marble Palace, for the last 30 years, is not going around burning bridges with people, because guess what? The guy that you disagree with today may be the one you agree with tomorrow on some of these bills, and you just got to go forward. So, but in the end, you know what? The voters make up their mind about who's in the legislature, and it'll be up to them to decide what kind of people they send out there. I just want them to be aware of what's going on.
Jerry Cox, the president of the Family Council, I appreciate your work, sir. Thanks for coming on the program.
Always a pleasure.
All righty. Thank you. Folks, it's familycouncil.org. That's familycouncil.org if you want more information. They do great work. They've been doing great work for a long time. And that kind of concludes this issue. I think we had State Representative Ballinger on, and he said his piece about it. Jerry Cox said his piece about it. Still kind of a disagreement. One says it wasn't about tort reform. The other says it was clearly about tort reform. Anyway, we're going to kind of close the chapter on that. Folks, don't go anywhere. Back in a moment.